Thank you very much, Mr. Speaker. I'm pleased to rise to speak on Bill C-78, the government's family law bill. Now, as other honourable members have alluded to in this debate, issues relating to family law, by and large, fall within the parameters of provincial jurisdiction. However, Section 91, sub 26 of the Constitution Act provides that it is within the jurisdiction of Parliament to make laws with respect to marriage and divorce. In order to discuss Bill C-78, what it seeks to do in terms of updating family law and divorce legislation in this country, I think at the outset it would be helpful to provide some context to how divorce law in this country has evolved. Indeed, Mr. Speaker, the Divorce Act is a relatively new piece of legislation. It was passed in 1968, only 50 years ago. Prior to the passage of the Divorce Act of 1968, we had in this country a patchwork of laws with respect to divorce. In some provinces, there were no divorce laws, and as a result, it was necessary for couples to seek a private activist parliament in order to be able to obtain a divorce. In other provinces, divorce was possible if it could be established that there had been some wrongdoing in the relationship. Mr. Speaker, fast forward to 1968, when Parliament did pass legislation to provide uniform laws with respect to divorce. And the Divorce Act of 1968 remained in place until it was updated in 1985, which is when Parliament made some very significant reforms to divorce and family law. Among the changes made in the 1985 Divorce Act was to provide a single ground upon which divorce could be obtained, namely when there was a breakdown in the relationship. Now, a breakdown in the relationship could be established based upon a number of different criterion, including 1 year of separation amongst the couple, or if it were established that there was adultery in the relationship or physical or mental abuse. Now, since Parliament took steps in 1985 to update divorce law in Canada, over the last 30-plus years, there has been very little changes that have been made to update family law in this country. And I've got to tell you, I was born in 1984, 1 year before the Divorce Act was updated. So it's 1984 or 1985 was a long, long time ago. And Canadian society has evolved considerably in these last 33 or 34 years, including the structure of families, unfortunately, the increased prevalence of divorces and marital breakdown. And so it is about time that Parliament is moving forward to consider a comprehensive update to the Divorce Act. Now, Mr. Speaker, in terms of the substance of this bill, let me say that we're open to looking at it carefully. On the surface, it would seem that this bill contains a number of positive measures. Among the key substantive aspects of this bill includes updating terminology, encouraging families to settle disputes outside of the court, improving child support enforcement, and preserving the well-being of impacted children. Mr. Speaker, all of these measures on the surface appear to be a step in the right direction. In terms of the road to reform, it has been, as I mentioned, a long time coming. And we saw a very thorough review undertaken by Justice Cromwell back in 2013. One of the key recommendations from the Cromwell Committee was the need to update terminology. Right now, under the Divorce Act, the terminology is quite adversarial. And that is not helpful, Mr. Speaker, as families deal with what is often the most difficult times and most challenging times that couples can face when they are in a situation where there is marital breakdown. And so, Mr. Speaker, among the changes that Bill C-78 would make would be to change the language, to make it less adversarial in accordance with the recommendations of the Cromwell Committee. So, in what ways would the bill make the language in the Divorce Act less adversarial? Well, for example, it would replace the term custody with contact and access with parenting, Mr. Speaker. Another aspect of the bill is that it is going to encourage parties to try to settle disputes through mediation or alternative dispute resolution. Far too much money is spent in our courts, and to the degree that families can settle their marital matters outside of court, outside of what is, by definition, an adversarial system, is a step in the right direction. And of course, Mr. Speaker, as I alluded to, it will codify what is, at this time, a wide body of case law to make and have regard for the best interests of the child. Mr. Speaker, I know in talking to an acquaintance of mine who was a judge, he said to me that upon being appointed, one of the challenges, of course, was to get up to speed on different aspects of the law that he had never practiced. For example, he had never practiced criminal law before. And so there was certainly a lot of time that he had to spend to get up to speed. But he said, aside from the academic side, aside from getting up to speed with different aspects of the law, what he found to be the most difficult was trying to settle disputes when children were involved in terms of making orders respecting parenting, for example, because so often he's there making a decision that is profoundly going to affect the parents, profoundly affect the family, profoundly impact the child. And so, Mr. Speaker, I just make that anecdote to underlie the gravity and the importance and the impact that these changes will have. And so we will, as I say, look at the bill, study it at committee. I guess we will trust, but we will verify at committee and look forward to hearing from a wide array of witnesses and, of course, explore possible amendments. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member opposite for his speech, and I noted that he acknowledged some of the very strong provisions in the legislation with respect to putting children first and enforcing child support payments. I want to ask him about the bill's impact on women, and the context of my question is a couple of statistics. We know that 96% of all those people who are in what are called registered maintenance enforcement agreements involve payments of men to women. We also know that 60% of all of those that are registered in these maintenance enforcement provisions are in default, and the default is in excess of $1 billion. So while this bill will impact on children in a positive way, I wanted to hear the members' comments on how it will impact on women, because we very much feel that this is at the heart of a feminist approach towards government and putting women, including middle-class women, first. Thank you.
Honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker. Let me first of all thank the Parliamentary Secretary to the Minister of Justice for his question and also congratulate him on his appointment as Parliamentary Secretary. I've had an opportunity to get to know the Honourable Parliamentary Secretary over the last 3 years, and I know his background as a lawyer, that he'll be well suited to his new role, and look forward to working with him closely on the Justice Committee. Look, he raises a valid point about issues around collection, issues in respect of women who often are disadvantaged in a divorce or a marital breakdown, and there's no question that it really has a significant financial impact. I mean, oftentimes people are losing half of what they have when there is a divorce. So all I can say is that we will look very carefully at the bill, and we'll work with the government, with the Parliamentary Secretary in a constructive manner to hopefully craft the best possible legislation for women, for families, and for children in Canada.
Questions and comments? The honourable member for North Okanagan, Shuswap.
Thank you, Mr. Speaker, and I thank my colleague right beside me here for his intervention this morning. It's a little bit awkward for me to get up and stand and speak on a divorce bill, having actually enjoyed almost 40 years of a very happy marriage. So it's a little bit awkward speaking on a divorce bill. But although we've had a very happy marriage, we've also a number of friends that have gone through uncomfortable divorces. And one of the things that comes up, and it's been mentioned as part of this bill, is the child support payments. And I would like to ask my colleague if this bill gets to committee, that he will ensure that there are phrases and language in the bill that can address some of the ways that the individuals are avoiding payment by working for cash. They're not actually paying income tax. None of it is reported to Revenue Canada. It's under the table. It can't be seen by the courts. I'd like to ensure that he can look at wording to address that issue in the bill. Thank you, Mr. Speaker.
The honourable member for St. Albert, Edmonton.
Well, thank you, Mr. Speaker. I thank my colleague for Okanagan, Shuswap, for his comments, and I certainly agree with him in terms of the importance of the matter that he raised. But seeing that my time is nearly expiring, on a slightly more partisan note, I do want to say that it is a bit ironic that Bill C-78 makes, among other things, and rightfully so, the paramountcy of the best interests of a child. What a contrast to Bill C-75, which is currently before the Justice Committee, which waters down sentences for a whole host of serious offenses that directly impact children, including kidnapping a minor, forced marriage under the age of 16, and I could go on. The government is treating those offenses that directly impact children from serious indictable offenses down to hybrid offenses that could be punishable by a mere fine. So while it is encouraging, as I say, that we are focused on the best interests of the child in this bill, I only wish that the government would have the best interests of the child in all bills, including Bill C-75.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
So, and I appreciate the member's comments, both in his speech and also in his most recent responses to the questions. But what I would put to him is that you see strong statements in Bill C-78 with respect to defining family violence for the first time in a much more expansive way, giving judges actual tools to use in interpreting family violence. And I would put it to the member opposite that I find actually in strong consistency and strong thematic consistency with Bill C-75, which you just mentioned, which goes into intimate partner violence. And I would also say thematically that what both bills are trying to do is reduce reliance upon lawyers like me and lawyers such as many in this House who are involved in part of the overly litigious nature of the family law system. By encouraging people and giving them the tools to remove themselves from the court system, what we were doing is reducing some of the backlogs that characterize that system, which is a goal that I think the member opposite and those on this side of the House both share. And I would put it to him that those two are in fact compatible goals and that the legislation is moving in the same direction.
Yeah, the honourable member for St. Albert, Edmonton.
Well, Mr. Speaker, Bill C-78 does appear to contain a number of measures to, among other things, combat family violence. And we welcome, Mr. Speaker, improvements in order to address the very serious and systemic issue of family violence. We've always stood up for the safety and well-being of children and families as Conservatives. And again, I reiterate that I, along with all of my colleagues, intend to work closely with the government to achieve some of those objectives that are very, very important.